A multi-billion-dollar setback for the Trump administration. A federal judge has cleared the way for thousands of businesses to receive refunds for tariffs. Fox Business correspondent Lydia Hu has the details.
A federal judge has ordered the administration to begin refunding billions of dollars in tariffs. More than 2,000 companies have filed lawsuits seeking refunds, according to reports, and many of them are big businesses like Costco and FedEx looking to benefit from the tariff challenges initiated by small businesses. The federal judge's order comes after the Supreme Court invalidated some of Trump's tariff powers last month. The order directs U.S. Customs and Border Protection to begin recalculating duties importers paid and determine exactly how much money needs to be returned. On top of returning tariffs paid, where estimates range from $130 billion upwards of $175 billion, the government revealed in a new court filing that it will also pay interest on the refunds, estimated to be nearly $700 million per month.
Welcome back again to Dr. John Podcast. A federal judge has ordered the return of $166 billion in tariffs collected from over 330,000 importers across 53 million entries, ruling Trump's Liberation Day policy was never legal. The administration's signature economic agenda is now a massive liability, with interest on the refunds still owed. Now, before we go into the full breakdown, let's be clear about what this headline actually means in plain English. The money being paid back is not coming from Trump's personal bank account. That is not how this works. When the government collects a tariff, it goes into the federal treasury.
The group that represents the small businesses say they can now go back to planning their businesses.
I have one business that I talked to who was on a waiting list for 2 years for a piece of machinery so that he could manufacture in the United States, but the machinery was coming from a highly tariffed country. So now perhaps he'll be able to buy that machine.
The refund process remains unclear. The government says it will be a painstaking endeavor requiring manual review of millions of import entries, but others are pushing back, insisting this process could be automated. The federal judge will hold a private conference tomorrow to hash out the refund process. This court order directing refunds comes after the president and administration officials suggested refunds would not be automatic.
Well, that was Lydia Hu reporting. Democrats like Senator Elizabeth Warren are amplifying calls for those refunds.
When that tariff is declared illegal and a judge orders refunds, the refund comes from the federal treasury. So it is the United States government, meaning American taxpayers, paying back the American businesses that were made to pay an illegal tax. Yeah, that is the full circle here. American importers, many of which are American companies, paid a tariff that was declared unconstitutional. And now the American government has to give that money back, funded by the same government budget that the tariffs were supposed to be helping fill. Come on. And on top of the principal amount, there is interest. Estimates show the interest was accruing at roughly $23 million per day while the cases were pending, nearly $700 million per month in interest alone.
Now, the U.S. Customs Commissioner is being ordered to appear in court over a massive tariff refund dispute that could involve about $166 billion in repayments to importers. A federal trade judge wants answers on why the refund process is taking time and whether the government is moving fast enough to return the money after tariffs were struck down by the Supreme Court. At the center of this case is the U.S. Court of International Trade, where Judge Richard Eaton is overseeing how billions in tariffs later ruled unlawful should be refunded. The judge has now ordered Customs and Border Protection Commissioner Rodney Scott to appear in person on June 9th, demanding a clear explanation on when businesses will actually get their money back. Customs officials say they are already processing over $35 billion in refunds, covering more than 8 million import entries. But the total exposure could reach $166 billion. According to court filings, the refunds stem from tariffs imposed under emergency powers that the Supreme Court later ruled invalid.
So the longer the refund process drags out, the more it costs. And the administration is doing everything it can to drag it out. Here's the background on how we got here. The Supreme Court struck down Trump's tariff regime built on the International Emergency Economic Powers Act. The court said the president has no authority under that law to impose sweeping global tariffs because the Constitution gives the power to tax and impose tariffs to Congress, not the executive branch. That ruling instantly invalidated over $160 billion in tariffs that had already been collected. And it set off a legal scramble in the U.S. Court of International Trade, which is the specialized federal court that handles trade and customs cases, to figure out what happens next.
Now, the legal fight has shifted from are refunds owed to how fast they must be paid. Customs has said that the system is handling massive scale, over 15 million import entries reviewed so far, and that some payments are already reaching businesses. However, delays remain for firms missing bank or entry details. With billions still in limbo and a judge demanding answers in court next month, the pressure is now on customs to prove it can deliver one of the largest refund operations in U.S. trade history on time and at scale. And to give us more details on this, our correspondent Suzanne Tehrani had sent us this report from New York. Take a look.
The head of the U.S. Customs and Border Protection is being ordered to testify in court over delays in refunding billions of dollars in tariffs ruled illegal by the U.S. Supreme Court. The dispute centers on sweeping tariffs imposed by President Trump under the emergency powers laws. Earlier this year, the Supreme Court ruled that the president overstepped his authority, opening the door.
How does the government give back 160 to 166 billion to 330,000 importers across 53 million entries? Who is responsible for sorting that out? What is the legal mechanism? How long does it take? And critically, does every importer get a refund, even if they did not file a lawsuit? Those are the questions that landed on Judge Richard Eaton's desk. And his answers have set off one of the largest and most complicated refund processes in the history of the federal government. And before we get into the mechanics of the refund order, let me give you one more number that puts the whole situation in perspective.
For importers to reclaim an estimated $166 billion in tariff payments, a federal trade judge now wants customs officials to explain why the refund process is moving slowly and when companies can expect their money back. So far, the government says that about $20 billion has already been returned, with tens of billions more still pending. The case is now becoming a major test of presidential trade powers and could reshape how future U.S. tariffs are imposed. The hearing is expected to take place here in New York on June 9th. Susan Tehrani reporting from New York for WION World This Way.
The interest on these tariff refunds was accruing at roughly $23 million per day. $23 million per day in interest on money the government was not legally allowed to collect. So every single day that the administration fights the refund process in court, the total amount owed to American businesses grows by another $23 million. Every single day. By the time the Supreme Court issued its ruling, the government had been collecting these tariffs since Liberation Day. That is roughly 10 months. The accumulated interest on $166 billion over that period at the federal post-judgment interest rate is substantial. And it keeps growing every day that the refund process is delayed, appealed, and fought in court. Come on. The administration's delay strategy is not free. Every week of delay at $23 million per day adds about $161 million to the total liability. Every month of delay adds roughly $700 million. Every year of delay adds roughly $8.4 billion to the total obligation. So the choice to fight this in court rather than comply quickly and efficiently is not just a legal strategy. It is a financial bet. A bet that winning the appeals will save more money than the interest cost of delaying. And the legal experts and trade law specialists who have studied the Court of International Trade's unique statutory framework closely are not giving the government particularly good odds on winning that bet. Let's talk about Judge Richard Eaton and his order, because the scope of what he ordered is genuinely extraordinary. Eaton was assigned as the sole judge to handle all tariff refund cases by the chief judge of the Court of International Trade. That means one judge is overseeing the process of unwinding over $160 billion in tariff collections across the entire country. And in his order, Eaton did something that the Trump administration absolutely did not want him to do. He ruled that the refunds apply to all importers who paid these tariffs, not just the ones who filed lawsuits. He used the court's unique nationwide jurisdiction to issue what lawyers call a universal refund order. The court's language was clear. All importers whose entries were subject to these duties are entitled to the benefit of the Supreme Court's ruling, whether or not they had filed formal legal challenges. Come on. That is a judge saying it does not matter if you took the initiative to sue or not. The tariff was illegal. You paid it, you get it back. And here is what makes that legal move significant, and why the government immediately pushed back so hard. The Court of International Trade has something unusual under federal law. It has national geographic jurisdiction and exclusive subject matter jurisdiction over trade claims. That means it is the only court in the country with authority to hear tariff refund claims. And because of that unique statutory framework, Eaton ruled that the Supreme Court's earlier restriction on universal injunctions does not apply to this court's relief. Most federal courts cannot issue orders that apply to everyone in the country who is not a party to the specific case before them. The Court of International Trade can, and Eaton used that authority to make every importer in America eligible for a refund without requiring each one to individually file a lawsuit. The government's lawyers looked at that ruling and immediately said no. The Justice Department argued that customs cannot reliquidate, which is the technical term for recalculating and reopening import entries for importers whose entries have already become final through a legal process called liquidation. And they said the court does not have authority to issue this kind of universal relief. The scale of the operational challenge is also genuinely staggering. Customs and Border Protection told the judge in a court filing that the task of finalizing entry costs without assessing a tariff was unprecedented in scale and could require manual review of more than 70 million entries. They said they had collected about $166 billion in tariffs across more than 330,000 importers who made more than 53 million individual shipment entries. And they said they needed up to 4 months just to assess their options for paying refunds. 4 months to figure out how to start. And then the actual refund process would take additional time after that. At $23 million per day in interest, 4 months of assessment time before even starting to pay is hundreds of millions of dollars in additional interest costs. Yeah. The administration's reluctance to comply quickly was not just legal strategy. It was fiscal strategy. The slower the refund, the more time to figure out if they could avoid or narrow it. And in the meantime, the interest clock was running every single day. So Judge Eaton suspended his immediate compliance order after Customs and Border Protection filed a declaration explaining that it could not immediately execute what he had ordered, but he did not drop the order. He just paused it while Customs figured out a system. And within days, Customs was in court, describing a new electronic platform it was building that allows importers or their customs brokers to file electronic refund requests by uploading a spreadsheet of their entry numbers. The system then automatically removes the tariff charges and recalculates what was actually owed, effectively processing each entry as if the tariff had never existed. By the time reporting on the system was current, the platform had processed roughly $85 billion in potential and certified refunds, with about $20.6 billion forwarded to the Treasury Department for actual distribution. Are you kidding me? $85 billion in refund claims submitted through an electronic portal that did not exist before this year. This is wild. And the government is fighting every step of the way to narrow the scope of who gets paid back and when. Let's now talk about what the government is arguing in its appeal, because this is where the political and legal fight gets very specific. The Justice Department is challenging Eaton's universal refund order at the Court of Appeals for the Federal Circuit. The core argument is that for entries where the liquidation process has already become legally final, meaning the entry has been closed, and more than the statutory protest window has passed, the government is not required to reopen those entries and issue refunds. The specific dispute is over entries that have been finally liquidated for more than the statutory window. Lawyers estimating the scope of finally liquidated entries put them at around $30 billion or more in tariff payments that may be in a legal gray zone. The government's position is essentially that some importers were too slow to file protests, the window closed, and therefore, even though the tariff was illegal, they do not have to give the money back for those entries. A former senior commerce official who reviewed Eaton's order described the language as suggesting an across-the-board approach where importers are entitled to refunds, full stop. The government's appeal says full stop should have some exceptions, and the Federal Circuit is going to decide who is right. Let me also walk you through something that has not gotten nearly enough attention, which is the legal case that originally brought the refund order into existence. The case is called Atmos Filtration, Incorporated v. United States. Atmos Filtration is a small company, not a household name, not a massive corporation with an army of lawyers and unlimited legal resources. It is an importer that paid these tariffs, believed those tariffs were illegal, and brought a case in the Court of International Trade to get its money back. And that case became the vehicle through which Judge Eaton issued a ruling that now entitles 330,000 importers to refunds. One small company's lawsuit triggered a nationwide refund order covering 166 billion and 53 million shipment entries. Can you believe this? That is the legal system working in a way it was designed to work. A party with standing and a legitimate legal claim brings their case to the right court, and the court's ruling has nationwide effect because the Court of International Trade has nationwide jurisdiction. One case, one company, one judge, and 330,000 businesses are now entitled to refunds. Let's also talk about what the liquidation dispute actually means, because it involves a technical legal concept that has billions of dollars riding on it, and almost nobody outside the trade law world understands it. When a company imports goods into the United States and pays duties on them, the customs entry goes through a process called liquidation. Liquidation is when Customs and Border Protection makes a final official determination of the duties owed on that shipment. Once an entry is liquidated, the importer has a specific window to file a protest challenging the duty amount. If they do not file a protest within that window, the liquidation becomes final and conclusive under federal trade law. And ordinarily, once that window closes, the importer loses any right to challenge the duty assessment or seek a refund. Now, here is the problem that the refund order creates. Some importers paid their tariffs. Their entries were liquidated, and the protest window closed before the Supreme Court struck down the tariffs. Those importers did not file a protest because they did not know they needed to file a protest to preserve their refund rights. They did not know there was going to be a Supreme Court ruling declaring those tariffs unconstitutional. Nobody did. And Judge Eaton's amended order took the position that even those finally liquidated entries are entitled to refunds, not just the ones still open, all of them. The government's appeal specifically targets this aspect of the order, arguing that the finality of those entries should stand and that the government is not required to reopen them. The amount at stake in that specific dispute is estimated at roughly $30 billion. $30 billion hinging on a question about whether the customs law finality rule can override a judge's order to refund a tariff the Supreme Court said was unconstitutional. That is where the case is right now. So let's break this down. There are 4 things I need you to understand clearly when you leave this video. The first is about what $130 to $166 billion actually means in context. This is not abstract government accounting. This is money that was paid by real American companies. Large companies like FedEx and Costco, which import massive volumes of goods and pay significant amounts in tariffs, but also small importers. The companies that bring in specialty food products, manufacturing components, textiles, electronics, and thousands of other categories of goods, more than 330,000 of them. These companies price their products, planned their budgets, and made their business decisions based on the tariff costs they were paying. Some of them raised prices to cover the tariffs and pass those costs directly to their customers. Some of them absorbed the costs and squeezed their profit margins to the point of real financial pain. Some of them shifted their entire supply chains, spending millions in the process in response to tariffs they thought were permanent. And all of them paid into a system that the Supreme Court has now said was never legal. The refund is not a windfall for these companies. It is a return of money they were not supposed to have to pay in the first place. Come on. The framing of this as Trump paying back billions is accurate in the sense that his administration's policies created this liability, and his administration is now fighting in court to avoid paying it. The second point is about the interest and why the delay strategy backfires financially. At approximately $23 million per day in interest, delay is expensive. Every month, the government drags out the refund process. The total amount owed grows by roughly $700 million. The 4 months customs said it needed just to assess its options would add roughly $2.8 billion to the total refund obligation before a single check was cut. The appeal to the federal circuit will take additional months. If the government eventually loses that appeal, as legal observers say is likely, given the Court of International Trade's unique statutory framework, the delay will have added billions more to the total liability. And the administration is also appealing the scope of the universal refund order more broadly. Each appeal buys time. Each day of time costs $23 million. The delay strategy is costing the American taxpayer money in real time. Yeah. Every single day that the government fights this in court, the interest clock keeps running. The third point is about what this refund situation reveals about the real cost of the tariff policy. The Trump administration framed these tariffs as a revenue generator. The money collected would fund other priorities. It would give the administration leverage in trade negotiations. It would show the world that America was serious about trade enforcement. And in the short term, the revenue was real. $166 billion collected over the period the tariffs were in effect. But that revenue was always conditional on the tariffs being legal, and they were not. The Supreme Court says so unanimously in its core finding. And now the entire revenue stream has to be returned with interest, which means the tariff policy did not generate net revenue for the government. It generated a temporary loan from American businesses that the government now has to pay back at interest rates, making the whole thing a net negative for the federal budget. This is wild. Trump framed tariffs as the government making money from trade. What they actually turned out to be under judicial review was the government borrowing money illegally from American importers and then paying it back with interest. And here is one more dimension that ties the political story together with the legal and financial one. The Trump administration has been arguing throughout this entire process that it was justified in how it handled the tariffs, that the authority was a legitimate use of emergency powers, and that the Supreme Court got it wrong. The keep calm and tariff on social media posts from the White House after the Supreme Court ruling was not just bravado, though. It reflected a genuine belief inside the administration that there are other legal paths to maintain tariff pressure even after losing on this authority. And that belief has driven an alternative approach of leaning more heavily on other tariff authorities, which are based on national security findings and unfair trade practice investigations. Those authorities are slower and more limited in scope. They cannot be applied globally with a single executive order the way the previous authority could. But the administration is pursuing them anyway. And while all of that is happening, the refund clock is ticking. Every day, the new system is processing claims. Every day, the $85+ billion in submitted refund requests grows. Every day, the interest meter runs. And every day the Federal Circuit appeal remains pending is another day importers are waiting for money that a federal judge has already said they are entitled to receive. The administration has created a situation where it simultaneously claims the tariff policy was justified and is fighting in court to avoid paying back the tariffs that were declared unjustified. You cannot simultaneously win both of those arguments in the same legal system. And so far, at every level, from the district court to the circuit court to the Supreme Court itself, the courts have not let them do that. The fourth point is about what comes next in this legal fight and why it matters for every American who pays for imports. The Federal Circuit appeal of the Universal Refund Order is pending and will determine whether the $30+ billion in finally liquidated entries gets paid back or not. The new system is processing refund claims in Phase 1. But Phase 2, which covers more complex entries, including those with anti-dumping or countervailing duty complications, is still being worked out. Eaton has continued holding hearings and demanding compliance reports from Customs and Border Protection. And separately, the question of what replacement tariff authority the administration can use going forward is still being litigated across multiple courts. The alternative tariff mechanisms Trump has pivoted to after losing on the original authority are slower and more narrowly targeted. They cannot replicate the sweeping global coverage of the previous regime, and they are subject to their own legal challenges. And let me give you one final thing to hold on to, because it connects the tariff refund fight to the broader story of this administration's relationship with the law. Trump ran on tariffs. He said tariffs were going to be the answer to trade deficits, the answer to American manufacturing job losses, the answer to revenue needs, and the answer to negotiating leverage with foreign governments. He called Liberation Day a historic moment. He said foreign countries were going to pay. And in the narrow sense that tariff revenue came in, money did come in. $166 billion came in. But that money was collected under a legal authority that the Supreme Court said the president does not have. It was collected from American importers, not from foreign governments. It drove up costs for American consumers through price increases. It disrupted supply chains that companies had built over decades. And it now has to be returned with interest, funded by the American taxpayer. The foreign governments who were supposed to be paying did not pay. American businesses paid, and now the American government is paying them back. That full circle is the story. It is the gap between the political promise and the legal, financial, and economic reality. And it is going to keep playing out in the Court of International Trade, in the Federal Circuit, and in the cost of goods on store shelves for years to come. Are you kidding me? This is what a policy built on a legal foundation the courts rejected actually looks like when the courts finally say no. Stay locked in, because the Federal Circuit ruling is coming, the next phase of refund processing is coming, and the next chapter of the trillion-dollar tariff story is going to tell us whether the administration can find a legal path to the trade policy it wants, or whether the courts keep drawing the same line they have been drawing since day one. Make sure you're subscribed, because this is going to keep developing and changing. This story is far from over. Hit that subscribe button. I'll see you next time.